So we are learning a topic, revocation. We've seen an example. I mean, X offering to sell to Y 50 bales of cotton, but before Y accepting, X can revoke that. Instead, there is some time limit like 6 p.m. and all that. Even then, before acceptance, X can revoke anytime. Right? Now, there's another example. A proposes to sell his house to B. A proposes to sell his house to B by letter sent by post. A may revoke his proposal at any time before B post his letter of acceptance. Since yesterday, in the topic of communication, this has been, continuous sentence that we have been learning. So, what A before communication of acceptance by A, before B posts the communication of acceptance, A can revoke his offer. That is given in this example. Whereas B may revoke his acceptance anytime before the moment when the letter communicating the revocal reaches him. Letter communicating the acceptance reaches him. Now here, A sent a letter to B saying that I'll sell my house to you. Now A can revoke the offer. A can revoke the offer before that letter of offer reaches B. Similarly, for example, if B has given his acceptance, B can revoke the acceptance before the letter of acceptance reaches A. So this is the timing for revocation. Okay, an acceptance to offer must be made before that offer lapses or is revoked. Yes, just because there's an offer and you cannot wait for indefinite period of time to accept that, there should be particular lapsing reasonable period. Just as said, for fruits or vegetables we can consider 2 to 3 days. More than that, the goods will perish. So that's the reason there should be some reasonable time for the offer to accept. You cannot just keep it open for infinite period of time. Okay. The law relating to the revocation of offer is the same in India and in England, but the law relating to revocation of acceptance is different. Yeah. So usually, as I told you, this Indian Contract Act 1872, we just incorporated this from our British laws, that is the England laws. But few of the provisions we have just changed them according to our Indian Indian culture and nativity. Based on that, we have made few changes to the law adopted by us. So we'll see. Similarly, here they are saying that the law relating to the revocation of acceptance is different in India and England. We'll see what is that difference. In English law, the moment a person expresses his acceptance of an offer, the contract is done. Okay, the moment acceptance is given, the contract is done, and such an acceptance becomes irrevocable. Once acceptance is done, there's no concept of revocal of acceptance in case of English law. Be careful. That's not our law. In case of English law, once accepted contract is done, they cannot revoke it, whether it is made orally or through post. But in Indian law, the position is different. Yes, we have an option to revoke our acceptance. Okay, that means English law is very stringent. If you see, the moment acceptance is done, they are saying contract is done, you cannot revoke it. But Indian law has given us some flexibility, saying that though you provide your acceptance, you can revoke your acceptance. We'll see. Contract through post, as acceptance in English law cannot be revoked. Yes, so that once the letter of acceptance is properly posted, the contract is concluded. In Indian law, the acceptor can revoke his acceptance anytime before the letter of acceptance reaches the offerer. Here we have seen, right? Before B's letter of acceptance reaches A, he can revoke his acceptance. That is what is being said here. Anytime before the letter of acceptance reaches A, he can revoke before the telegram arrives, he can revoke that. Contract over telephone. A contract can be made over telephone. The rules regarding offer and acceptance as well as their communication by telephone or telex are the same as for the contract made by the mutual meeting of the parties. The contract is formed as, yes, in case of telephone or when the parties are face to face, it is done as soon as an offer is made and it is accepted. Okay. Otherwise, there will be no contract. When there is no acceptance, there is no contract, as communication of acceptance is not complete. If telephone unexpectedly goes dead during conversation, the acceptor must confirm again the words of acceptance. Just because suppose the offer said, I'll sell my car for 2 lakhs, the other party did not give the acceptance and hung the telephone, or the telephone goes dead, then in that case it can't be said the contract is complete unless the acceptance is again given in words. Okay. Revocation of proposal otherwise than by communication. Usually what we saw, revocation by communication, right? I mean, sending the letter of revocation or whatever. But there are few cases where revocation may happen even without communication. We'll see. When a proposal is made, the proposer may not wait indefinitely. As I said, there should be some, I mean, time limit or something like that. They can't wait forever like that. Okay. The offer can be revoked otherwise than by communication or sometimes by lapse. Yes, in case there's this lapse where the time period lapses, then the offer is done. You cannot accept later on. We'll see modes of communication, modes of revocation of offer. One is by notice of revocation, that we've seen the posting of letters and all that, that we've seen. By lapse of time, we'll see what is this lapse of time. The time for acceptance can lapse if the acceptance is not given within the specified time. Yes, if the time period is specified, the acceptance should be given within that specified time period. If no one comes back within that specified time period, no more offer, it just gets lapse. When there's no time period specified, within a reasonable time, you can go back to our fruits and vegetables example, there should be some reasonable time. Okay, this is for the reason that proposal should not be made to wait indefinitely. It was held in Ramsgate Victoria Hotel versus Montefiore that a person who applied for shares in June was not bound by an allotment made in November. Yes, this person has applied this. Montefiore has applied for shares in the month of June, but this Ramsgate Victoria Hotel Company allotted shares to him in the month of November. There should be definitely some period of time, right? Offer is made in June and accepting in November. There's a lot of time gap. So in these cases, the offer will get lapse. The same decision was followed in the India Cooperative Navigation and Trading Company Limited as and versus Padmaseb Premji. So the same decision. You can't say you've made applied for shares in June, they come back in November and then they said take the shares. That's not permissible. There should definitely be some time limit after that, after which the offer will lapse. But now they are saying that these kind of in the case of shares lapsing within certain time period and all that are not valid in the context of allotment of shares now, because Companies Act 2013 has many rules with respect to this. Or Companies Act 2013 in itself, it is answering all these questions. I mean, when can the shares be allotted after the application is made and all that. So now these rules are no more applicable for the allotment of shares. You can consider this example for some other offer getting lapsed and all that. By non-fulfillment of condition precedent, yes. Where the acceptor fails to fulfill a condition precedent, there might be some conditions like you will have to deposit. Suppose 2 lakhs is the car price, our favorite example. But if there is a condition like you need to deposit rupees 25,000 before so and so date, okay, before 15th. For example, B doesn't deposit this before 15th, then we can consider that the offer is lapsed because the time period is done. So that's one example. The condition precedent to the acceptance must be completed. See, and executing a certain document, just like depositing, there might be you should execute a promissory note before 15th. If this is a condition, if you have not executed the promissory note before 15th, the offer will be lapsed. A has got every right to sell it to other party. The similar example is given. Leases his lands. B refuses to lease the land. The offer of A is revoked automatically. Here the example is where A proposes to sell his house to B for 5 lakhs provided B leases his land to A. But if B refuses to lease the land, then the offer is automatically revoked. Okay. This is section 6. Section 6 says that if the condition precedent to the acceptance is not done, then the offer is deemed to be revoked. By death or insanity. Death or insanity of the proposer would result in, obviously, when there is no party to perform that particular contract, automatically it gets revoked. But only if the fact of death or insanity comes to the knowledge of the acceptor. Yes, I mean, if it doesn't come to the knowledge of the acceptor would be in thinking that there's a contract still going on and all that. Once that death or insanity comes to the knowledge of the acceptor, then it is automatically revoked. My counter offer. We've seen counter offer, right? What is the counter offer? A says, I'll sell my house or car, whatever, for 2 lakhs. But B says, I won't purchase it for 2 lakhs. I can purchase it for 1.5 lakh. In this case, this is a counter offer. We've seen in case of counter offer, the original offer will be cancelled. Once the counter offer is made, now B's 1.5 lakh offer is in existence, the original offer will be lapsed. So, what are the modes of revocation? One is by notice of revocation, that is outright communication through letter, post, through letter or telephone, whatever. By lapse of time, by non-fulfillment of condition precedent, by death or insanity, and by counter offer. So, these are the 4 modes by which offer can be revoked. How? Yeah, there's one more. By the non-acceptance of the offer according to the prescribed or usual mode. Yeah, I told you in some cases offerer might be very stringent, saying that only if you post the letter of acceptance, I'll consider it as acceptance. If you send a mail or something like that, I won't accept. If that is the case, then if instead of sending a letter, if he's sent an email or telegram, in that case the offerer has every right to say that the offer has lapsed because you have not sent the acceptance in the prescribed mode. A subsequent illegality, maybe while entering into the offer there is no illegality around. In some states, usually this happens with liquor. At the time of entering into offer there won't be any ban or something like that. After entering into the contract, or after sending out the offer or something like that, then there will be a ban imposed by the government. In that case, because of subsequent illegality, the offer will be no more in existence. That can be said to be revoked. So here we have all the summary. You can quickly go through. So every topic of what we have covered is just summarized in here. That's the contract, offer and acceptance, communication of offer and acceptance, and revocation. Okay, meaning of all the terms. So everything is clearly mentioned in here. Promisor and promisee, consideration. Please go through that. Okay, void contract. But now that we've learnt every point to point, though you go back through the entire study material, that will be done in half of the time, because you're aware of. I did not even miss a single point in here because this is how we studied, and so we could get tracks and all that just because we've studied each and every point without missing it. An agreement enforceable. Go through these questions. Pretty simple. And if you see below, we have theoretical questions as well. Every topic was covered in our class. If you see question 1, all contracts are agreements, but all agreements are not contracts. This was covered, right? But then you'll have to elaborate what are the points that were there, and define the term acceptance. Discuss the legal provisions relating to communication of acceptance. Yes, we have many communication of acceptance is to be made to the person who made the offer, and all the legal rules were there. You'll have to list down those, and distinction between wild and illegal also we have covered. Okay, just quickly go through these answers and all that. And our first chapter or first unit, nature of contracts, is done. Okay, just quickly go through all these answers. We'll get started with our next chapter in the next video.